1941. Blizzard conditions stall traffic in the state. Some things never seem to change in the state of Wyoming. Chief Clerk, please call the roll.
Convening roll call for the 30th day, Wednesday, February 22nd, 2023. Alamand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clauston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrop? Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Slagle? Smith? Stiff? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washut? Western? Winter? Wiley? Yin? Zwanitzer Dan? Zwanitzer Dave? Speaker Summers?
Chief, could we leave that roll open? Did you get Representative Walters or? Okay. I'd like to welcome Rabbi Moshe Halfon of Mount Sinai Congregation for our prayer of the day.
This is weird. There we go. It's on. Good morning, ladies and gentlemen. Like yesterday, I'll be brief, but the introduction may take longer than the saying. As I said, I've been doing little pithy things from our tradition. You may have heard of Rabbi Hillel. He was a contemporary of Jesus. And there's a book, you can look it up online, called Ethics of the Fathers, or we call it Pirkei Avot, little sayings. So it starts out by describing Hillel and Shammai, were two scholars, contemporaries, received the Torah from their previous people. Hillel would say, be of the disciples of Aaron, a lover of peace, a pursuer of peace, one who loves creatures and draws them close to the Torah, to, God. But this is the one that I want to leave you with. You can put it up on your wall. He used to say, if I am not for myself, who will be for me? But if I'm only for myself, what am I? And if not now, when? So that may be your watchword, right? If I'm only for if I don't take care of myself or my district or my area, then who else is going to do it? But if I'm only taking care of myself, then I'm a selfish person. And if not now, when? Thank you very much. God bless.
Thank you, Rabbi. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The House will please come to order. That little bit of light we see down there is the light at the end of the tunnel, ladies and gentlemen. We're getting closer and closer. Chief Clerk, will you finish the roll, please?
Chadwick? Heiner?
Heiner.
Sherwood?
Excused.
61 present, 1 excused.
Journal Committee report.
Your Journal Committee reports that the Journal of February 21st, 2023 has been read and recommends that it be approved. Representatives Chestick and Ward.
Our doctor of the day is Marilyn, or maybe it's our nurse of the day, excuse me, is Marilyn Moore, RN from Cheyenne Regional Medical Center. Please help me welcome her. Thanks for joining us in the House today. We appreciate it. Messages from the Senate.
Message 385, Mr. Speaker, Senate File 32, prohibiting drones over penal institutions. The Senate failed to concur on House amendments to the bill listed above by the vote indicated. Ayes 4, noes 26, excused 1. Message 386. Mr. Speaker, the Senate appointed Senate conferees to meet with the Light Committee Number 1 from the House on amendments to Senate File 32. The Senate conferees are Senator Landon, Chairman, Senator Cooper, Senator Nethercott. Message 387. Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 16, State Employee Moving Expenses. Ayes 16, noes 13, excused 2. Message 388. Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 38, Special License Plates, Organ Donations. Ayes 23, noes 8. Message 389. Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 178, Mountain Lion Pursuit Seasons. Ayes 18, noes 12, excused 1. Message 390. Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 21, High Occupancy Vehicle Lanes. Ayes 17, noes 14. Sincerely, Ellen Thompson, Senate Chief Clerk.
We are at that order of business of Senate files on first reading. The first and only Senate file for our consideration today is Senate File number 72.
Senate File 72, sponsored by Senator Larson.
First reading of the bill.
Employees forced microchip implantation prohibited.
Senate File number 72 is referred to Committee number 10, Labor. Reports from standing committees.
Senate File 151, sponsored by Senator Hutchings, Wyoming Prescription Drug Transparency Act, an act relating to the insurance code. Mr. Speaker, your Committee Number 3 Revenue, to whom is referred Senate File 151 engrossed, Wyoming Prescription Drug Transparency Act, respectfully reports same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Zwanitzer. Representative Harshman, Chairman.
this time, we'll do re-referrals. Chairman Harshman. That would be Senate File number 151.
Thank you, Mr. Speaker. Senate File 151, Mr. Speaker, I'd like to re-refer. It has a small appropriation to Committee Number 2 Appropriations.
Without objection, Senate File 151 is re-referred to Committee Number 2 Appropriations. Chairman Washut, I believe you have one on Senate File 120.
Mr. Speaker, I'd like to re-refer Senate File 120 to Committee Number 2 Appropriations.
Without objection, Senate File 120 is re-referred to Committee Number 2 Appropriations. We're at that order of business of bills on second reading. The first bill for our consideration is Senate File 75.
Senate File 75, sponsored by Blockchain, Decentralized Autonomous Organizations, Amendments, an act relating to corporations.
Senate File 75, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 97.
Senate File 97, sponsored by Senator Hicks, Education Trust Fund Transfer, an act relating to Wyoming Education Trust Fund.
Senate File 97, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 123.
Senate File 123, sponsored by Senator Boner, Military Dependents, School Choice, an act relating to education.
Senate File 123, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 129.
Senate File 129, sponsored by Senator Landon, Background Checks, Governor's Office, an act relating to criminal history records.
Senate File 129, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 131.
Senate File 131, sponsored by Senator Hutchings, Prohibition of delivery of unsolicited ballot forms, an act relating to elections.
Mr. Speaker,
Can I finish the Senate File 131? No. Representative Zwanitzer.
Thank you, Mr.
Is
Speaker.
there an objection, I guess?
According to Rule 7-3, I'd like to move Senate File 131 back one additional day.
Hearing no objection, Senate File 131 is laid back one day. Representative Chairman Brown.
Mr. Speaker, pursuant to Rule 7-3, I'd like to move Senate File 137 back one additional day.
Seeing no objection, Senate File 137 is laid back one day. The next bill for our consideration is Senate File 148.
Senate File 148, sponsored by Senator Kinski, Preemption of Local Firearms Regulations, an act relating to weapons.
Senate File 148, having been read two separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Trying to sweeten me up with donuts. It'll work, I tell you. Representative Bear, I think this is the end of second reading, so all right, we are ready for just a second. All right, we are at that order of business of request to concur with Senate amendments to House bills. The first message for our consideration is message number 384 on House Bill 229. Chairman, somebody help me out on this. House Bill 229, message 384. Chairman Brown.
Thank you, Mr. Speaker. I would move message 384 to House Bill 229 for concurrence. And after speaking with the sponsor of the bill, it sounds like these were just some cleanup amendments, and they would ask for an aye vote on this. As you see here, there was just a couple of things in here on the 3% for the fees to make sure that the language was cleaned up there a little bit on the first two, and then on the last one, the cost of processing the transaction, just making sure that we're not overcharging anybody with this particular bill. So again, the sponsor of the bill has asked for an aye vote. Sounds like this was a pretty good cleanup, so asking for aye on concurrence.
We are voting on the motion to concur with Senate amendments to House Bill 229. A majority of the elected members is required. Chief Clerk, please call the roll.
Allemand. Allred. Andrew. Angelos. Banks. Bear. Berger. Brown. Burkhart. Byron. Chadwick. Conrad. Crago. Davis. Eklund. Haroldson. Harshman. Heiner. Henderson. Warnock. Jennings. Knapp. Larson Lloyd. Larson JT. Lawley. Locke. Nyman. Newsom. Nicholas. Nemec. Northrup. Oakley. Obermuller. O'Hearn. Olson. Ottman. Pendergraft. Penn. Provenza. Rodriguez-Williams. Sherwood. Singh. Slagle. Smith. Stith. Storer. Strock. Stivar. Tarver. Trujillo. Walters. Ward. Washut. Western. Winter. Wiley. Yin. Zwanitzer Dan. Zwanitzer Dave. Speaker Summers. Are there any changes? Are there any changes? Closing vote. Vote closed. 62 aye.
By your vote, you have voted to concur with Senate amendments to House Bill 229. Chief. We are at that order of business of consideration of joint conference committee reports. The first report for our consideration is Joint Conference Committee number 1 on House Bill 16. Representative Chairman Crago.
Thank you, Mr. Speaker. I move the Joint Conference Committee Report number 1 to House Bill 16 and would ask for an aye vote. So what we did in this particular report is the Senate, our colleagues down the hall had changed the terminology of current market value to depreciated market value, which really didn't make a whole lot of sense because depreciation is included in market value. And so we took that out, went back to our position, which is current, but then we added the word remaining on useful life, which is really what they were trying to get at down the hall. And that was the portion that we were probably a little bit confused on our end. And so we added the word remaining, but went back to the current market value versus depreciated market value. And I would ask for an aye vote.
We are voting on the Joint Conference Committee number 1 to House Bill 16. A majority of the elected members is required. to adopt the report, the chief clerk will please call the roll.
Ellerman, Allred, Andrew, Angelos, Banks, Bear, Berger, Brown, Burkhart, Byron, Chadwick, Chestick, Clauston, Conrad, Crago, Davis, Eklund, Haroldson, Harshman, Heiner, Henderson, Hornock, Jennings, Knapp, Larson Lloyd, Larson JT, Lawley, Locke, Nyman, Newsom, Nicholas, Nemec, Northrup, Oakley, Obermuller, O'Hearn, Olson, Ottman, Pendergraft, Penn, Provenza, Rodriguez Williams, Sherwood, Singh, Slagle, Smith, Stith, Storer, Strock, Stivar, Tarver, Trujillo, Walters, Ward, Washit, Western, Winter, Wiley, Yin, Zwanitzer Dan, Zwanitzer Dave, Speaker Summers. Are there any changes? Are there any changes? Closing vote. Vote closed. 61 aye, 1 no.
By your vote, you have voted to adopt Joint Conference Committee Number 1 to House Bill 16. Mr. Majority Floor Leader.
Mr. Speaker, I move the House resolve itself into committee of the whole.
You have heard the motion. All those in favor say aye. All those opposed, no. Motion carries. Representative Ward.
The House will please come to order. The first bill for our consideration is Senate File 79, Plan of Safe Care Newborns. Reading clerk will read the bill.
Senate File 79, sponsored by Senator Baldwin, Plan of Safe Care Newborns, an act relating to public health and safety. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 79 engrossed, Plan of Safe Care Newborns, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Chadwick, Clauston, O'Hearn, Trujillo, Yin, Zwanitzer. Noes, Representatives Hornock, Penn, Ward. Representative Zwanitzer, Chairman.
Majority Floor Leader. Vice Chairman Yin.
Thank you, Madam Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File number 79 do pass. And I will turn over explanation of the bill to Vice Chair of Revenue.
Chairman Oakley, Vice Chair Oakley.
Thank you, Madam Chairwoman. Members of the House, I bring to you Senate File 79 and ask for your favorable consideration. So what this bill does, this bill creates a more uniform process to identify and help infants that are born with and identified by doctors as being affected by substance abuse or withdrawal symptoms resulting from drug or alcohol exposure, and to make sure that they're connected with resources and treatment and all of that. Excuse me. I'm going to take a little privilege here with so many new members on the floor, just to let you know that I brought a bill last year regarding women using methamphetamine while pregnant, specifically criminalizing that, which actually sailed through the House, but eventually did not make it out the other side. And so what I think we see here is an attempt at addressing these very serious issues. My take on it, of course, was I thought it needed some serious teeth. But we rejected sort of that highest sanctioning, and this is an effort to assure that it's addressed, maybe creating a set of baby teeth or something, and some uniformity of process in requiring birthing hospitals to have a means to identify these children and mothers and to develop a plan, which really brings us to, the title of the bill here is Plans of Safe Care. So that these are developed and we're all on the same page that before that child and that mother leave the hospital, something is put in place, and currently we do not have that. So on the bill, kind of starting with, there's some definitions, but page 2B is really where the action starts. So it says, when an infant is born with and identified as being affected by substance abuse or withdrawal symptoms resulting from prenatal drug or alcohol exposure, a member of a patient care team, so a doctor, shall develop a plan of safe care in cooperation with the parents or guardians, and specifically to ensure the safety of the infant and address the health and substance use treatment needs of the infant and the family members. Next, to ensure that appropriate referrals are made for the infant and affected family members upon discharge, and that also includes referring them to intervention and education programs. It says the plan of safe care shall take into account whether the infant's prenatal drug exposure was because of, whether the infant's mother is or will be actively engaged in ongoing substance abuse treatment. Next page on 4, section D says, if applicable, a copy of this plan of safe care shall be provided to appropriate community partners involved in the future care of this child. And I think then going on to section F is important, because if the patient care team identifies a safety, an actual safety concern for the infant, they will make a mandatory report to local child protective services, which already exists in statute. So this refers to that Title 14, Chapter 3, Article 2, which is that child protective services piece. So that doesn't change that. So what this does is, where they've identified a child that has needs, but maybe there's, they've got a sober father, so they aren't concerned for the actual safety of the infant, or they think something can be worked out and maybe referred to other programs. But this doesn't change that piece where if they are concerned for the infant, they would report that to the Child Protective Services. And so what's important about this bill is currently Wyoming does not have a requirement to establish a plan of safe care. So this creates that uniformity with healthcare providers. And also what this will then create is a reporting mechanism for the Department of Family Services to be able to start looking at the numbers. What kind of problem are we having with this in our state? Because we know it does exist and we know it's happening, but we don't have this reporting mechanism. So that also has them forwarding these plans of safe care to the department so we can start getting a handle on what we're looking at. And so without it, there is more of a possibility that infants who are substance exposed could be overlooked. Possibly mothers don't have the support for their addiction. So this is trying to put all of that in place. And so finally, I guess what I'd like to say, I know we've gotten some emails and some pushback, I guess, if you will, about this bill. And I think perhaps there's a lack of understanding about what it does and doesn't do. We're, trying to help infants, help mothers. I guess we're not going to throw them in jail. So this gives us that opportunity to start putting things in place. And finally, I'd like to encourage anybody to look at the digest. It's listed there, and see the broad support that this has received all along the way from committees and the other side of the house. So the other side of the, down the hall. So this has been very well received, and I would encourage your aye vote.
Representative Penn.
Thank you, Madam Chairwoman. So when this was presented in committee, unfortunately I wasn't there, but I was watching the replay afterwards, and I just had some more questions that maybe can be answered. So it was mentioned just a moment ago that the hospital has a process in place to identify these infants and mothers. And I'm just wondering, where do we see what that is? Because I don't see reference to such a procedure or protocol in this bill as far as that it would be in statute. The only reference here is on page 2, subsection B. It says when an infant is born with and identified as being affected by substance abuse or withdrawal symptoms. And so I guess I'm just wondering, how are we coming to that determination that they have been identified? And I guess the reason that the confusion for me comes is, it was just presented as this being something that would be identified at the hospital. But when this was presented in committee, the author of the bill was presenting it more of this being as a child presenting to a primary care clinic. And he mentioned something about if I see that an infant is breathing slowly, then that might give indication that maybe, there's drug withdrawal, or, there's something to be concerned about. And so I just would hope that maybe I could get some clarification on that. Thank you.
Representative Hornock.
Thank you, Madam Chairman. I was in the committee listening to this, and I want to bring up a couple of points that I think we need to think about as we're considering this bill. First of all, this is critically important to really get right, because we get this one wrong, and we're dealing with taking away babies from mothers. And so it's pretty critical that we kind of get this piece right. Now, that being said, we don't have a statewide plan in place for something like this. And I would argue that I don't think we need one. Currently, we heard testimony in committee that the hospitals themselves are working this out. They have systems in place that are tailored to their hospital, tailored to their facility. And so this is, again, trying to make kind of a one-size-fits-all approach that we're going to create throughout the state where there is mandatory reporting. And I emphasize that because I think what the reason why the hospitals are inclined to favor something like this is because actually we're, again, taking the liability off of the hospital themselves to create a program that they follow, and we're putting that liability on us as the state. So rather than and as a hospital administrator, I'd be all for something like this. Having the state tell me what I have to do so that when a mother and a child are in my care at the hospital, I have to, and there's the possibility that there is substance abuse involved, then I have to report that to the authorities, and it takes away my liability completely. So, you know, the hospitals will still be involved in this, but they have to report this, and then it follows up the chain. I think that's something that we're looking at, rather than allowing each individual hospital, each care unit to kind of look at the circumstances, look at who's involved, and tailor their response to each individual circumstance. This is a problem in Wyoming, unfortunately, and I don't think we're going to solve it by creating a statewide care program that throws these individuals into a care program where there's mandatory reporting, where they can follow this, and the state then tracks that individual and makes sure, you know, the state then tracks that individual, basically. So I just don't think that we are necessarily doing the right thing by cutting the piece of pie exactly the way we want it, putting a box around everything exactly the way we want it to be. I think that we need to leave it up to the hospitals. We need to leave it up to that agency to figure out how they want to handle this. And so I would caution this bill. It's important to get this right. And so I would caution you on this bill, and I would urge you to vote no. Thanks.
Chairman Washit.
Thank you, Madam Chairman. Let's step back and look at child abuse in Wyoming, right? Child abuse in Wyoming is a mandatory reporting law. If a child comes into an emergency room, appears to have been abused, the doctors are obligated by statute to report that. I think that's a good law. And I think probably most people in this room think that's a good law. So now we're talking about this baby who just comes into the world, right? And these hospitals, when those babies are born that have been exposed in utero to these chemical substances, they know what that looks like. They see the seizures, they see the health complications. And when they see these babies, they go, these are the indicators, like do any other disease or ailment that might beset a newborn, right? If the baby comes out jaundiced and yellow, they have a protocol to address that. When we have a baby that comes out having seizures or other indicators of substance abuse, they have a protocol to address that. What this bill does, you might say, well, why do we need a statewide consistency? Because we don't want to miss babies. You know, when you have a hospital like we have in my county, lots and lots of babies get born in that hospital every year, and we see lots of them. That's not true in every hospital, okay? Some of our counties are aging, and we don't have as many babies being born as we used to. So a statewide protocol allows us to make sure that a baby doesn't slip through the cracks. And if you care about the well-being of the baby, that's what this bill is all about. Please vote aye.
Chairman Larson.
Thank you, Madam Chairman. Following on to the good chairman of judiciary, I just remind, as you read the bill, the statewide implication is that we're requiring all the hospitals, the healthcare providers, to provide a health care plan. That's as far as the liability extension. We're just saying to the hospitals, those providers, that if there's a trigger, that if this baby is identified of having a substance addiction, and it doesn't have to be illegal, it doesn't have to be an illegal drug, it might be a drug that the mother was taking that affected the baby also. They're just saying that we then need to develop the providers at the hospital and the coordinators in cooperation with the infant's parents, big deal, I think, families or guardians if the parents are struggling, in order to ensure the safety and the well-being in the infant. And what does that look like? In trying to protect the family, this is all about the baby, and to then help the families know that your child has this addiction, and as he's well enough or she's well enough to leave the hospital, here are some resources that are available to you. And it's all in this care plan. And so one of those, as it identifies there on page 3, enrollment 3, is a referral to the local early intervention education program. Our child development centers, remember, 2 by 2 visits by 2 years of age, to make sure that those children don't have any developmental delays. We want to make sure that those babies that have had these addictions are being looked at not only by their primary care providers, if they have one, but then to just make sure that they're transitioning and moving out of this addiction into a normal lifestyle without complications or any, but if there are developmental delays, what are the resources to help them through that? We do get back into the page to the point that according to the Comprehensive Addiction Recovery Act, the patient care team will make sure that the Department of Family Services has a list of all the children that are on that have received that type of plan. And then, as the good chairman of Judiciary pointed out, if there is an situation that the healthcare team thought that the infant's health or safety was in peril, that they would then contact Department of Family Services, and in their normal process would determine the best interest of that child. Stay with parents, stay with another family member, or in some sort of foster care. But please don't look at this bill and think that that's the automatic trigger, that if there's an addiction, then the intent is to take that child away. In fact, it's just the opposite. It's what do we do to keep the family together and to make sure they understand the resources available to them as this child works through this addiction process. I think it's a good bill as well, and would hope for your favorable consideration.
Representative Pendergraft.
Thank you, Madam Chair. As I read through this bill, I see on, I believe it's page 3. Page 3, line 2 says a member of the patient care team shall develop. And you folks here in this body have taught me to be aware of whenever there's the word shall versus the word may. So my question is it possible that this patient care team might look at the situation and realize that in one particular case, the family has this under control? Do they have an option to put out a healthcare plan that says this is taken care of, no further intervention is necessary? And might that word shall be replaced with may to give that patient care team the discretion as to whom they report? A little farther down, line 13 on the same page, they will ensure that appropriate referrals are made for the infant. Who gets to determine what is an appropriate referral? Is there somewhere in another document or another statute, is there some sort of a guideline so that these people understand what is and what is not appropriate, or is it just left strictly to them? And the final question for now, on the next page, starting at line 11, Patient care team shall report the total number of infants and families for a plan of safe care, et cetera, pursuant to the Comprehensive Addiction and Recovery Act. I don't have a copy of that available. So I would like to know what that report looks like. As we report the number of infants and families, does that report also include names? What all is involved with that? That information would certainly help me. Thank you.
Chairman Brown.
Thank you, Madam Chairwoman. So what I would say I want to kind of tell a brief story, but I want to explain a few of the questions that were just asked, and I think it's really important to make sure that we go back and read the entirety of the bill, not just portions that we have concerns with, because this is incredibly important that when we look at this language on page 2, it does say, actually it's on page 3, sorry, and it's lines 3 and 4 that this I think is probably the most critical piece, and that's why I was a co-sponsor, why I am a co-sponsor on this particular bill. It is in cooperation with the infant's parents, families, or guardians. Everything that follows below this section is in cooperation with. So when we talk about ensuring the safety and the well-being of the infant that this body has said must happen, it's in cooperation with the family member, the infant, of the infant. It is with the guardians. It is with the parents, whomever that ends up being. When we address the health and substance use treatment needs of the infant, it's with the parent. And when we ensure that those appropriate referrals are made, it's in cooperation with the parent. It's also a larger team, right? This is not just a standard, hey, the doctors say that you got to go do this, so this is what's going to happen. No. That's not what we're saying here. And this leads me into my story, right? So I had a very, very close friend of mine. Was going through, certainly wasn't postpartum depression, was going through prepartum depression, and was prescribed antidepressants during her pregnancy. And when she was described these antidepressants, it was kind of a last resort, right? We know we don't want to necessarily prescribe something like this, especially to something that in utero. We know that there can be adverse effects. And I'll tell you that little baby breaks my heart. I'll never forget it. Came out completely withdrawing from that side effect from those drugs of having for the past 3 months being on antidepressants. It was going through that baby's blood, and then when the baby comes out, it's no more, right? And the mom and the dad, for the first 2 weeks, were terrified. They could not fathom what they were about ready to experience when they walked out of that hospital. The doctors told them, the baby's going to experience side effects. The baby's withdrawing, okay? What they did not understand is how severe those side effects would be. This is not only about narcotics and illegal substances. This is about that situation where a very close friend of mine's baby was experiencing such severe withdrawals that they took that baby into the emergency room 3 different times because they thought the baby was going to die. The baby would not stop crying. It was shaking. It was the most indescribable thing I've ever seen in my life, to watch an infant of 4 or 5 days old going through withdrawal symptoms. This bill, the reason I signed on to this bill is for that friend of mine that would have been provided this patient care team and would have had the appropriate referrals, would have had the appropriate care information provided to them when they left the hospital, to know that this is who to contact, this is what we're going to be looking for. Maybe if something nefarious was happening, then they would refer this to Department of Family Services, right? Because if we don't have this bill and there is something that is thought to be nefarious, then this particular situation goes through the judicial system. It's out of the hands of the doctors. Without this plan of care in place, it becomes up to the judges, the unelecteds, the people that have no idea what's being practiced across the street over here in the hospital. With this piece of legislation, we're saying if you have a baby that's addicted to anything, we are going to create a statewide health system that understands that when this occurs, you're given the tools to make sure that that baby, when it's born and it's suffering from that addiction, it has the capability of surviving, and the parents understand exactly what's going to happen from that point forward. This, in my opinion, ladies and gentlemen, this is probably one of the more important pieces of legislation that I've had the honor of co-signing onto. After witnessing what occurred to my friend's baby and witnessing what the terror that they went through because they were not provided this information, this is the type of information that we should be providing. And I've received hundreds of emails saying that this is a scary bill and we're taking parental rights away, and we're not. Literally everything is in consultation and cooperation with the infants, parents, families, or guardians, everything. And if we don't do this bill, we take that away, it goes into the judicial system, and it's not in consultation, it's not in cooperation with. So I urge the body very heavily to think about the black helicopters that are circling all these bills. They're not circling this bill. This is a really good piece of legislation, and this protects those infants that we care so much about. Thank you, Madam Chairwoman.
Representative Stivar.
Thank you, Madam Chairman. I don't know where I stand on this bill. Problem is I have a real good, my partner, wife, is an MSW, and she said it on more than one occasion. A social worker can mess up a normal situation, the unintended consequences of this bill. We need to stop and think about that. A well-intentioned person can mess up something that would be normal. So stop and think about this, guys.
Representative Pendergraft.
Thank you, Madam Chair. And I mean this very sincerely, and I'll explain why in just a second, appreciate the comments given by the good chairman from this county. And I have tremendous empathy for this because it happened to us. I have a deceased stepbrother who was adopted. When we picked him up, or when he was picked up, I was not there at the time. He was, much as this child earlier was described, detached. His teenage mother had used, we don't know what all drugs, caused all kinds of problems. And my brother grew through most of his life never fitting in, having all kinds of issues, if I may say, a strange child. He later died of suicide. This means a lot to me too, and I appreciate this legislation. But as was expressed very early on by one of the earlier speakers, we have to get this right. And so, yes, I did read the entire paragraph, that it does include the parents, families, and guardians. However, sometimes these people are not necessarily willing to cooperate. And so that's where my question comes in. If they fail to cooperate, it seems that the answer was then it's going to go to the courts, and the courts are going to decide. And that's a tough thing. I don't know that there's a right answer, but I just want to explore this, and I want to have this conversation. So if, for example, the family is not cooperating for whatever reason, and then this begins turned over to the state, my questions that I raised earlier, they still stand. Who decides what is an appropriate referral? And how do we establish that? Is there a one-size-fits-all answer? I doubt it. Most situations are very, very different. Anything that we do here must be done, as I've kind of beat to death, very, very carefully. So again, I'm more than willing to proceed and to continue the conversation. I just want to be very careful that we get it right. Thank you.
Representative Provenza.
Thank you, Madam Chairwoman.
this bill, I think, comes from over a year of conversations with the folks in this state that have the most knowledge and expertise and experience with these issues. So there's a steering committee that involves folks from Department of Health, Department of Family Services, and numerous physicians who work on specifically in this issue. And there was some really compelling testimony that was brought during the interim about this. And so these aren't brand new conversations that are being had. A lot of this has been discussed in depth, has been tried in other states, and has been proven to work. The scientific evidence behind this shows that on average, when they looked at over 787 newborns that fell under this plans of safe care model, they reduced the number of days that they were in treatment in the hospital by threefold. So instead of 15 days, they went down to 5. Using this works, and providers have shared very personal, compelling stories about that. Not only does it work for the infant and give them better health trajectories and outcomes, it also benefits the parents in terms of going through recovery and coming out on the other side. It's just tremendously helpful. I think in addition to that, we're seeing that the amount of treatment that has to be used, so whether that be medications or otherwise, for infants that are born with substance withdrawal symptoms is just far less. Those long-term outcomes definitely also show that this is beneficial. So this isn't a new conversation. And certainly there is a group of physicians, there's a group of pediatric doctors, there's all these folks who are behind this. This isn't just this new blue piece of paper that nobody thought about. So I would encourage you to support the bill. Thank you.
Chairman Zwanitzer.
Thank you, Madam Chairman. I'm just going to quickly move committee of the whole amendment number 1, which is just a grammar fix that LSO caught. Figured it was a nice time to break in the debate. So if you look at the sentence, it started with prenatally or, and we're amending that to be an active voice sentence and ending it with the word prenatally. So ask for your favorable consideration on Standing Committee Amendment number 1 for better grammar in the bill.
Question having been called. All those in favor say aye. Opposed? Standing Committee Amendment number 1 to Senate File 79 has passed. We're back on the bill. Representative Penn.
Thank you, Madam Chairman. I'm still hoping that I can get an answer to my original question about what are we talking about when we say that the kid has been identified as, and I know that there was some discussion of it, but this, as mentioned before, this bill walks a very fine line, and so I think it's important that we get into the actual details, because yes, absolutely, we want to protect our drug-addicted babies. I don't think that there's much question on that. But the other thing is we also have to protect our babies and our families that could be adversely affected if we have a situation where we have a overzealous pediatrician, or so let me tell you a situation that I'm aware of, and likely some of you may also be aware of a story that has happened in the last year with an infant that this bill would not have saved this little baby. So in our neighboring state that grows lots of potatoes, there was a baby who was, I think he might have been a little premature, but he had developed had a GI issue that was causing him to struggle to gain weight, and he was vomiting, he was having a hard time keeping things down. And the parents had been involved with healthcare. The child had been admitted to the hospital, had undergone lots of testing. They didn't come up with answers. They sent the child home with instructions to continue to follow up with their pediatrician, doing regular weight checks, and the mom was compliant with that. One day the child started throwing up again. She took him into the pediatrician. They didn't find anything. They said, okay, come back on Friday and we'll do another weight check. And so that was the plan. Well, Friday morning, this mother woke up and was ill herself. And so she called the clinic and she canceled their appointment. And the pediatrician called DFS, took that to mean that there was a risk or a safety concern to this child, and they called DFS. Even though there previously had been no indication that this child was at risk, the parents were actively working with providers. And so what ended up ensuing with that is they issued, I think they call it a BOLO, be on the lookout or something, for these parents, because when they went to the home to take the child, they weren't there. And so ultimately the police officers found the father's truck, pulled it over at a local gas station, and all of this stuff can be witnessed. It's all on video because the mother videoed it, but the officers ended up, they arrested the aunt of the baby because they thought it was the mother. They arrested the father of the baby, and they took the child, and they put the child in the hospital, and the parents weren't allowed to go near it or see it, and family members as well. And I can't remember exactly, it was a week or two that the child was not allowed to see its parents. And so there are situations where we may have overzealous pediatricians or unethical social workers who, with this language being vague here, could say that, so on page 4, line 16, that the patient care team identified a safety concern. So most of this is talking about drug addiction, and I fully support that. But I would hope that we would have some more concrete language going back to page 2 when we're talking about being identified as. And so the mention was that the hospital protocols have these things in place to identify them. What is that? Has the child had a drug test? Has the mother had a drug test? Have labs been done? Has this child been evaluated for these things before these events start, this cascade of events takes place? Because it's a very fine line, and we want to protect our babies. We want to protect our babies. We want to protect our babies, both sets of babies. And so we have to be very, very careful here. And so I'm hoping that maybe we can come up with some better language to help put some guardrails on this, because we don't want this going the other direction. Thank you.
Representative Warnock.
Thank you, Madam Chairman. Just another point on this. We need to decide kind of where we stand as a body, because on page 4, it says, if applicable, a copy of the plan of safe care shall be provided to the appropriate community partners involved in the infant's future care. So I guess the question with that is, what does future mean, and when does it end? Do we want to be the body that kind of takes over taking care of people literally from cradle to grave in this situation? I don't think that's where we want to go. This kind of puts us on that trajectory. So it's just something for the body to think about of how we want to handle this kind of thing.
Chairman Zwanitzer.
Thank you, Madam Chairman. Quickly to answer some of those questions and just clear up some of the confusion, right? So when an infant or a mother comes in, an infant's born, there's no blood test you give. It's basically a verbal conversation with the doctor, the OBGYN's observation in the nursery to determine, at least up front, if there is a substance abuse disorder with the infant. Again, mandatory reporting is only for law enforcement and for hospital personnel. So you can't have an overzealous social worker come take away your kids without the police or the hospital doing so. The plan of safe care, when it ends shorter than a judicial proceeding would if that child is taken into protective custody. And all of the things in this bill would be mandated once that child's in a foster system, and all of these contacting auxiliary services would happen automatically. This bill is a way for that same level of care to happen without taking that infant from the parent. And that's really the crux of the bill and why it's so important that if we can work these out without a judicial proceeding and taking away those kids, that's what we're hoping to do with this bill. So hopefully I answered those questions. maybe not to the best of the questioner's desire, but you determine a substance abuse infant through observation conversations with the mother, family members, observation in the nursery, those type of endeavors.
Question.
Question having been called, all those in favor of Representative Oakley's motion that when the committee of the whole rises to report, it do so with a recommendation that Senate File 79 do pass. All those in favor say aye. Aye. All those opposed? Senate File 79 has passed the committee of the whole. The next bill for our consideration is Senate File 98. The reading clerk will read the bill.
Senate File 98, sponsored by Senator Barlow. Education Certificate of Completion, an act relating to education. Mr. Speaker, your committee number 4, Education, to whom is referred Senate File 98, Education Certificate of Completion, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Allred, Andrew, Berger, Brown, Clauston, Lawley, Northrup, Obermuller, Provenza. Representative Northrup, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman? Chairman Northrup.
Thank you, Madam Chairman. I move that when the committee of the whole rises to report, do so with the recommendation that Senate File number 98 do pass. There are no amendments, and here with the explanation is the good doctor from the Northeast.
Representative Clauston.
Thank you, Chairwoman. So this bill comes to us from the concern of many school districts in our state. It's passed unanimously on all votes to date. The concern being that when our students with disabilities who are on an IEP age out from the school district, they don't receive a diploma. They're actually designated as a dropout and they count against our school's graduation rate. What this bill does is it requires the State Board of Education to work with our school districts and create a certificate of completion so that when these students accomplish their individual goals in their IEP, they are recognized. It shows the value of their work and the work and the commitment of their families and their educators. This process will also provide uniformity across our state and provide information to the state on how many of these students are accomplishing the goals of their individual IEP. Hopefully this certification program can morph into an alternative diploma, as in other states, where these students' goals are valued and they are no longer counted against the true graduation rate. I stand for questions and I ask for your support on this bill and these students.
Question having been called, all those in favor of Chairman Northrup's motion when the committee of the whole rises to report, it do so with the recommendation that Senate File 98 do pass. All those in favor say aye. Aye. Opposed? Senate File 98 has passed the committee of the whole. The next bill for our consideration is Senate File 100.
Senate File 100, sponsored by Senator Barlow. Designation of spouses, revocation upon divorce or annulment, an act relating to wills and probate. Mr. Speaker, your committee number 3, Revenue, to whom is referred Senate File 100 engrossed, designation of spouses, revocation upon divorce or annulment, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Zwanitzer. Representative Harshman, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Madam Chairman. I move when the committee of the whole rises to report, it do so with a recommendation that House Bill 100 pass, and it has a standing, Senate File 100, I should say, and it has a standing committee amendment. The standing committee amendment is a cleanup on the word spouse. So I'd move and call for the question on that amendment, then we'll turn the explanation of the bill over.
Question having been called, all those in favor of Standing Committee number 1 to Senate File 100, say aye. Aye. Opposed? Standing Committee number 1 to Senate File 100 has passed the committee of the whole. We're back on the bill. Representative Crago.
Thank you, Madam Chairman. Members, I bring to you today Senate File 100 and ask for your favorable consideration. So what this bill does is extends an area of the law that we already have in the green books. So if at the back of the very back, I'm going to start at the back of the bill and work my way forward. At the back of the bill, there's a repealer, and that is 26118. And what 26118 does is, or what it says is, if you die, if you get divorced and subsequently die, in your will, you haven't changed your will after you get divorced, and your ex-spouse inherits under the will, that's no longer in effect. The terms of your will are ineffective, and in essence, in that case, if you haven't created a new will, it's as if you died intestate, i.e. without any estate plan or will, and so it would go according to state statute at that point. What this bill does is extend that same line of thinking or theory to other documents, which this bill calls governing documents. And those could be trusts, those could be payable on death bank accounts, those could be life insurance accounts. And really what it's trying to do is solve a problem, and we've seen this litigated actually in the Supreme Court several times. I actually was on one of those cases one time. And what it does is essentially clean up the situation where, for example, and oftentimes it happens in second marriages or third marriages, but where a couple gets divorced, the spouse forgets to remove the ex-spouse's name from an insurance policy, a bank account, and they die, and there's let's say, for example, a large life insurance policy. And instead of the deceased person's kids getting the benefits of that policy or that bank account, because they forgot to change that on the governing document, it goes to their ex-spouse. And so all this bill is doing is trying to clean up that situation, prevent litigation going forward, and make sure that the kids, the people who should be getting it, are going to get the benefit of that. Now, you can always go in, there's provisions in here, you can always go in after the fact and add back to your will. You can always go in and declare that you still want that to go to your ex-spouse, because that happens actually quite a bit. But you just have to do that. You have to take an affirmative action to do that. And that's pretty much the bill in a nutshell. I'd stand for any questions.
Representative Locke?
Thank you, Madam Chairman. And this is just really for clarification for me. So in a case where you had a will where there was an ex-spouse on it and your kids, is it a situation where the will is no longer valid, or is that ex-spouse now removed? I'm just trying to make sure I fully understand. Thank you.
Representative Western?
Thank you, Madam Chairwoman. Perhaps a point of a clarification, maybe I just didn't read it enough, where it says revoke any revocable. So silent in there is the irrevocable component. So if there is, some kind of, whether it's a spendthrift trust or whatever it may be that is irrevocable, that is not included in this. Just a little clarification. Thank you.
Representative Craigo?
Thank you, Madam Chairman. So I'll go last question first. That is correct. It does not apply to irrevocable documents. They fall under different rules, and we don't want to get in the middle of that. On the question before that, is the will valid? The will is still valid. What the bill says is it's treated as if the ex-spouse predeceased in this case, the person who created the will, the testate or testatrix.
Representative Allemand?
Madam Speaker, I don't like this bill much, because if I forget to take my wife out of the will, she gets wiped out of the will and I wanted her in. So what I have to do, I have to remember to go in and make darn sure that she's still there. And that just doesn't seem too right to me. Thank you.
Representative Craigo?
Thank you, Madam Chairman. I think there might be a little bit of confusion. It only applies to ex-wives, not current ones.
Question having been called, all those in favor of Chairman Harshman's motion that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 100 do pass, all those in favor say aye. Opposed? Senate File 100 is passed the Committee of the Whole. The next bill for our consideration is Senate File 154. The reading clerk will read the bill.
Senate File 154, sponsored by Senator Cooper. Energy Authority Project Financing, Refineries, an act relating to the Wyoming Energy Authority. Mr. Speaker, your Committee Number 9, Minerals, Business, and Economic Development, to whom is referred Senate File 154 engrossed, Energy Authority Project Financing, Refineries, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Banks, Burkhart, Conrad, Heiner, Knapp, Larson, Lawley, Tarver, Western. Representative Burkhart, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Burkhart?
Yeah. Thank you, Madam Chairwoman. I move that when Committee of the Whole rises to report, it do so with a recommendation that Senate File 154 do pass. There is a Committee of the Whole amendment on this bill that should have been a standing committee amendment, but we had to research one small issue first. So I would ask that we handle the Committee of the Whole amendment first and turn that over to the sponsor.
Representative Larson, I think.
Thank you, Madam Chairwoman. So I move Committee of the Whole Amendment Number 1 to Senate File 154 and ask for your favorable consideration. Members, this is just a cleanup amendment. The body on the other end of the hall added some language that has already been covered in current statute. And it's just removing that because we don't want to duplicate efforts. So if there's no discussion, I'll ask for the question.
Representative Heiner. Question having been called. All those in favor of standing committee or Committee of the Whole Amendment Number 1 to Senate File 154, all those in favor say aye. Opposed? Committee of the Whole Amendment Number 1 to Senate File 154 has passed. We're back on the bill. Chairman Burkhart.
Thank you, Madam Chairwoman. So with that, I'll turn the explanation of the bill over to the good Vice Chair of Minerals.
Representative Heiner.
Thank you, Madam Chairwoman. Before I talk about the bill, let me give you a little backstory about the Energy Authority for those that may not know the whole story. Back in 2020, we tried to consolidate all of these different efforts for energy and the different people within the state that were trying to forward our energy and our economy into one organization, and we called it the Energy Authority. And it says it was created to diversify and expand the Wyoming economy through improvements to the state's electric and energy transmission infrastructure, development, transmission, so on and so forth. So basically, it consolidated all the energy staff and functions into one spot. They assist with obtaining financing, funding for these energy projects. They provide assistance with permitting, siting, regulatory requirements. It basically covers the entire spectrum of energy, including all sources of generation, extraction, and distribution. After we created the Energy Authority, we had to expand upon it. We added coal for non-fuel products as another item that would fall under that umbrella. And the most recent addition was when we added rare earths and trona under that same umbrella. So now with this bill, with Senate File 154, we want to add refineries under that same umbrella. Members of the body, you probably are aware that Wyoming only has five refineries in the whole state, and most of those are owned by one company. With the energy transition from fossil fuels, there's a hesitance to build grassroots refineries. The last one was built in 1977. And actually, over the past 5 years, we've lost a total of 12 refineries that they've shut down because it's becoming more and more difficult with the regulatory environment that we're in. Fortunately, there's one being built right now in the state that's to the north and east of us. They started permitting 10 years ago, and they're hoping to start it up this year. There's also one that's on the southwest of Wyoming in the other state. They started 8 years ago, and they're still in the permitting phase, and it's looking like it's going to die a horrible death. So what we've heard from the owner of most of our refineries in Wyoming is they are very hesitant to start a grassroots effort for a new refinery, but they are amendable to maybe expanding some of these refineries that they own now within Wyoming. So with this bill, it provides for help if they need some help with permitting, siting, finding funding, things like that, then the Energy Authority will help them. So if you go to page 2 of the bill, that's the meat of the bill right there to support efforts. The second half of that page, through that amendment, we just struck that out because it's already contained in the statute. And on page 3, most of that is all taken out with that amendment except for subparagraph O, which says that they may help with bonding or financing for the construction. So this basically puts the weight of the Wyoming state behind any efforts in the future to expand these refineries, should they desire to do that, and the Energy Authority will be able to help if called upon to expand our processing ability here in Wyoming. So with that, I stand for any questions, Madam Chairwoman.
Representative Hornock.
Thank you, Madam Chairman. With the amendment now, we've kind of struck the sideboards on the bonding amount. Is there now a limit to what this entity can bond? Or is it kind of whatever's out there through the roof?
Representative Heiner.
Thank you, Madam Chairwoman. The bonding has not been changed. It's still the same as it has been with all of these projects and authorities under the Wyoming Energy Authority. So yes, the bonding is available, has never been used to this date, but there's no changes in bonding.
Representative Larson.
Thank you, Madam Chairwoman. So the bonding is still in statute. It's just removing it from the bill itself. So it's still covered.
Representative Wiley.
Thank you, Madam Chairwoman. Look, folks, this is just a great protection for our legacy industries. I think we need to get behind it and support it, and let's keep our constituents working. Thanks.
Question having been called, all those in favor of Chairman Burkhart's motion that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 154 do pass. All those in favor say aye. Opposed? Senate File 54 is passed the Committee of the Whole. The next bill for our consideration is Senate File 107. The reading clerk will read the bill.
Senate File 107, sponsored by Senator Hicks. Acquisition, exchange and sale of trust lands. An act relating to state lands. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred Senate File 107 engrossed. Acquisition, exchange and sale of trust lands. Respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Allred, Conrad, Davis, Eklund, Slagle. Noes, Representatives Alaman, Banks, Winter. Excused, Representative Crago. Representative Eklund, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Eklund?
Madam Chairman, I move that when the Committee of the Whole rises to report it, do so with recommendation that Senate File 107 do pass. There's a committee amendment, I'd move Standing Committee Amendment Number 1 to Senate File 107 as well. And I'll turn over the explanation from the good member from the east side of the Bighorns, not western.
Representative Western.
Thank you, Madam Chairwoman. So on the amendment, let's just kind of dispose of that first. So it's more of a technical amendment that applies just right there to page 2. The session law in 1999 basically stated that threshold of what the state can or cannot go above, or there's kind of established that range. The amendment just simply sets the floor of 10,000 acres below the target number that was set in the 1999 session law. So state lands, the state must hold, or the office must hold, can't be 10,000 acres more or less than what was determined in 1999 session law. And so the amendment just simply puts that or less part of the 10,000. So I ask for your aye vote on the amendment. And if there are no questions, I call for the question.
Question having been called, all those in favor of Standing Committee Amendment Number 1 to Senate File 107 signify by saying aye. All those opposed? Standing Committee Amendment Number 1 to Senate File 107 has passed. We are back on the bill. Representative Western.
Thank you, Madam Chairwoman. So the genesis behind this bill is certainly from the perspective of a sportsman is this. You know, if you go on these new apps, these new maps that we have, you'll certainly in my part of the country, in the eastern part of the state, you'll see these little dinky chunks of state land that are surrounded by thousands and thousands of acres, sometimes public, sometimes not, right? And the reality is these little chunks of land that are identified in this bill as 80 acres or less, certainly from the sporting perspective, they don't really offer a lot of value because a lot of those ones are isolated by private land. So what this bill does is it allows the office to allow for the exchange or the sale of these little 80-acre chunks or less, provided, of course, that they are completely surrounded by private. So this situation where that little chunk of state land connects, you know, primetime BLM or not BLM, but other, excuse me, can't use formal names, you know, really high quality other public land, that little 80-acre chunk that connects that would not be eligible. Under this bill, the way it's written is that it has to be completely encumbered or surrounded by private land. And so it kind of sets that's kind of the objective here. You know, be happy to walk through the bill, but that's more or less what it does. It kind of creates, gives the agency rulemaking ability. It kind of provides opportunities or allows for the lessee of those grazing leases to be involved as well and to be notified and have that opportunity. If there are any questions, more than happy to answer them.
Representative Banks.
Thank you, Madam Chairman. So I was a no in committee, and I'll address my concerns and the reasons why I was a no. So if I've got a large piece of property that I'm using to graze my cattle, and it's on the side of the Bighorns, and I'm surrounding this little 80-acre piece of state land that I've been grazing for 20 years, anybody can go in and nominate that piece of property for this program for sale. And when we were talking to the Office of State Lands, they didn't give me a solid answer that I would be protected as a rancher who's had that grazing lease against somebody from a state along the coast who wants to go and build a cabin right in on that piece and wants to buy it out from under me. So those are the concerns I had, was if we can include something that talks about preference given to those who've been using this piece, who've been grazing that piece, I think I'd be more supportive of the bill. But that protection for the rancher who's been utilizing that piece just isn't in the bill. So those were my concerns and why I voted no. Thank you.
Representative Ottman.
Thank you, Madam Chairman. To go along with the last speaker, I know that there's been a family in this state who has been extremely affected by exactly that example. They've been fighting for years and really not been heard. And it is a problem because they have been on that property for years and years. And then, but my question to the bringer of the bill, my primary question is, why are these lands landlocked in the first place? I didn't think that was legal. Thank you.
Representative Western.
Thank you, Madam Chairwoman. So I think the gentleman from the Bighorn Basin brings up a really good point, and just had some juggling a lot of balls in the air and wasn't able to get an amendment filed for committee of the whole that I believe really addresses that concern there, and it's a very valid one. I've been working with the good gentleman that runs the floor at the other end of the hallway, who I've been conversing with over this bill for quite some time. And so the amendment that I'll be planning on filing for second reading, assuming that we allow this to move on, is this. It allows the leaseholder of the surface of those 80 acres, gives them a kind of a preferential right to purchase that land before anybody else. And so obviously there's constitutional concerns to ensure that the Board of Land Commissioners, as well as OSLI, is adhering on behalf of the fiduciaries. Are they acting as fiduciaries on behalf of the beneficiaries, public schools? So the concept is this. If someone nominates one of those 80 acres up for sale, the way it works is whoever currently has legal access to that 80 acres is allowed to match the final bid for those 80 acres. So if someone comes in from far away, or even someone who, other side of the state for that matter, nominates this chunk for sale, they go through the process, they make that bid. It allows the leaseholder to come in and say, you know what, I'm going to match that bid, and then that's it. They get that 80 acres. That's the end of the process. So it kind of allows for an avenue for the board to follow their mandate as beneficiaries, or not as beneficiaries, excuse me, as fiduciaries for the beneficiaries, while also ensuring that, that the little guy, the rancher who's been grazing that for decades and decades, also has the opportunity to buy that as well. So that's the amendment that again, I apologize for not having filed, but I will do so on second reading to allow that ability for those small ranchers so that they don't get totally shoved out of the process and they have some sort of preferential ability to keep that parcel. To the good retired teacher from the northwest part of the state, that's a long story of how those got there. And a lot of it goes back to the Organic Act and the Inception Act, so which we came into the state. I think the good coach from the center part of the state could give you a much more in-depth and detailed answer. But the long story short is that when we came into the union, those are lands that were granted to us by patent from the federal government, and those are lands all across the state. Over the last 100 or so years, some of those have been sold off chunk by chunk. Less so in the last 20 because some of those land sales have become quite controversial, and some of those are left over. Decades ago, a rancher bought a big chunk of state land, but there was that little 80-acre chunk that for whatever reason wasn't included in that transaction. That's certainly the case with some of them, but that's the bullet point version of the story without taking up the rest of the day to explain that. So that's the general gist, and I'm happy to answer any additional questions.
Representative Allemand.
Thank you, Madam Chairman. As the law reads right now, the land has to go to the highest bidder at auction. And until an amendment or the Constitution is changed, I'm very against this law, and I don't know if it's a constitutional change or just a statute change. I do not know that. But the state is going to be pitting California people against Wyoming ranchers. California person comes and buys one of, I can. The person comes in and buys one of these 80s, and he's got a lot of money. He can fight this in court, and he can get access to his 80 acres, even if it's 10 miles through somebody's private property. He's got the money. The poor rancher don't have the money to even fight him. So I'm very much against this bill. Thank you.
Chairman Washit.
Thank you, Madam Chair. Yeah, being a city boy, this isn't an area that I involve myself in much, but it seemed to me that the state lands that were checkerboarding around the state were designed for the long-term revenue source. And if we're selling them off, it seems to me maybe that's a little short-sighted, that we're not going to have those lands for the ongoing revenue stream for future generations. If you'd speak to that, please.
Representative Haroldson.
Thank you, Madam Chairman. So a question I have, do we have kind of a snapshot of how many parcels would qualify for this? Do we have an idea? Is this 25 parcels around the state that are 80 acres landlocked into private or less? Or do we have 250 or do we have 2,500? I mean, just kind of what are we looking at and what's the scope of this? And is there a minimum bid opportunity or how are they going to do the bidding? So, and it might be in there and I might have missed it, but I just was going to check on that.
Chairman Zwanitzer.
Thank you, Madam Chairman. Well, just to allay the good concerns of the representative from Natrona County, apparently on page 3, we're allowing the State Land and Investment Board to go ahead and help invest with our local people to compete with the private market with a farm loan, which seems a little interesting to me. We're selling it on one side and then paying money to let it be acquired under a farm loan in another section. I think my overall concern, though, is why would we ever sell state trust lands? Why would we not at least exchange them for something? It's a whole new section of law, which is concerning to me in 36.2.111. And we have had this provision about the 10,000 acres that we've dealt with for 20 years to the board. But all of a sudden now we're basically in state law saying there are some times that we should just sell our state trust lands. And maybe it's an isolated parcel of 80 acres, but I think that to proceed down, that just concerns me. We would start taking that step because I don't know what's next. And it also concerns me, we don't allow in this bill or in this clause in A, what if it's the federal government that wants to give us some lands? Can we exceed that 10,000 acres? And maybe that's a good second reading amendment. But I do think there's some times where maybe we could exceed that 10,000 increase depending on the circumstances, especially if the feds were to allow us to take some federal land and make that state land. I think we're better stewards.
Representative Slagle.
Thank you, Madam Chair. I could answer a few of the questions. There's 2,149 of these 80 acre or less parcels in the state for a total acreage of 109,277 acres. And the concern about selling off our state land, that's as you look in here, it talks about buying land as well. And so the idea that they put in that we talked about in the amendment, not more or not less than 10,000 acres. The idea is if people buy some state land, then the state land amount will go down by a certain amount. And so then if some property comes up or a person proposes to sell land to the state, then they can use the money they received from their other sales to purchase land. So that was the idea. That's why that plus or minus 10,000 acres is in there. So anyway, thank you.
Representative Western.
Thank you, Madam Chairwoman. I do appreciate the good rancher from the eastern part of the state clearing up some of those concerns. To the good chair of labor, I certainly think there's some valid points, but I think the conversation is getting a little bit off this bill. We start talking about federal land transfer, whole different deal, whole different discussion, whole different piece of legislation. I can understand initially the slippery slope thing. Look, I'm a big public lands hunter guy, so I get really touchy whenever there's any kind of talk about selling, exchanging, any of that stuff of public land. I think the big picture thing we have to ask is, how do we better manage public land or land that's owned by the state, right? From a habitat perspective, from managing wildlife, from the objectives and the trust objectives on behalf of the beneficiaries, it's just easier if we can consolidate these as much as possible. Sure, we could try to be really ambitious and go after those chunks of state land that are, 5, 10, 15,000 acres, but the stakes are way higher, way more just land involved. We're going for the low hanging fruit here. The reality is that I think from a lot of different perspectives, those little tiny 80-acre chunks in the middle of nowhere, certainly at least from a recreation perspective, from a wildlife perspective, they don't have a ton of purpose or value add. So the idea is, so long as we, of course, stay within that range that we are required to, this allows for that to happen in a way that we're not severing public access and that we're actually generating revenue on behalf of the beneficiary. We can already do this. Anybody can do this process right now under agency rule or the department rules. This is simply just taking the process that's on the books in department rule and putting it in state statute. That's all this is. There's nothing in here that talks about something that's totally new or that you can't do right now. It's just codifying in outer clarification there, which I think is good considering, I'm not going to go too far into it, but I think there's been plenty of examples where these kind of things were not handled consistently under agency rule, where if we have this in statute, it allows that to be in the green books. The chairman also talked about some of those farm loan, they're talking about on page 3, those are built, I think it's page 4, using those farm loans. That's simply for that rancher who's had the grazing lease to that land for decades and decades to have a low-cost financing option available should he choose, or should they choose to use credit to buy that 80 acres. It's certainly nothing they have to do, but it's just another tool in the toolbox for them in the event that they do want to acquire those 80 acres. So that's the explanation there. And I certainly hope that answers some of the questions. So.
Majority Floor Leader Nyman.
Thank you, Madam Chairman. Just a little bit of context is I have one of these. Actually, I wish I had one of the ones that he was talking about. Mine actually has a county road running through the center of it. And it's not fenced. And it is the biggest headache I have to deal with when hunting season shows up every year. Because any decent rifle will shoot clear across an 80 acre, actually it's 79.26 acres. And any decent hunting rifle will shoot clear across this mess. And so my Wyoming Game and Fish Department, the department that manages our game, spends a lot of time on that stretch of county road trying to keep people off of my private land, and spends a lot of time finding hunters because they shoot the animal within seconds. That animal's off of that little tiny piece of land and it's out into my hay fields, and they're asking me and they're wanting to drive out there and they're wanting to get them. Or I go out and I find all kinds of dead animals laying off the side of this little parcel of land that they didn't go after because they've got their onix. Well, it's on private land. I'm not even going to pursue it. So these little tiny spots of land that the state owns all over this state are a problem. They're a frustration on the part of not only the folks that want to enjoy our public lands because it's so small you can't really utilize it. And it creates a real heartache and a headache for the landowners that surround, like I do, completely this piece of property, minus this public access through the center of it. Because then we have to deal with and create all these kind of conflicts with hunters and anglers and everyone that want to enjoy our public lands. But it is a real frustration on our part because a lot of them are not fenced. They're small. You can't chase very much on them. You can literally park and look across it and see what's going on. And if there's nothing there or happen to be a piece of wildlife there that you can shoot, you shoot it, it's off of it. And immediately there's trespass. And immediately there's game and fish involved and all these different things. Or I just have to take the conscious effort to say, do whatever you want. If you have to, then go out and get it back. And then pretty quick, well, was it on the line? And so my issue with them is, and why I appreciate this piece of legislation, is they're too small. If you're talking about what some of the discussion here was that we talk about our checkerboards or our section 36 and 16s, which were set apart for generating revenue for our state, for our schools. That's a different deal entirely. You're talking about 640 acres, a mile square chunk of land, maybe isolated. Yeah, I can understand that. But these little 80s, we definitely need to work on this and try to figure out some way we can get them into the hands and then maybe transfer that land and get it to accessible land. We can actually make this work good for both parties, the sportsmen, the hook and bullet people, and also for the landowners. Let's try to trade these pieces of land to that landowner, save them the heartache of dealing with it, and purchase a piece of property already adjacent to a currently publicly accessible piece of property. So This is a good piece of legislation. I would encourage you to really consider it solidly. And you can save a lot of people a lot of heartache if we work on these type of legislation for both those that are the sportsmen and the landowners that have to deal with those issues. So I would support this piece of legislation.
Chairman Eklund.
Madam Chairman, I'd like to just kind of add a few things. The parcel described by the previous speaker, there's 2,300 of these scattered around the state. Some are completely isolated and inaccessible. Land exchanges are, sale or land exchanges are allowed. Land exchanges are actually the preferred method from the testimony that we heard from the state land office. Constitutionally, we have to maintain a certain number of state trust lands. That would happen. So the bill won't change that. The 10,000 acres or less was just added to put a minimum, I think, minimum or a maximum of over or under the acres you could have. Trying to think of what else wasn't answered or addressed. So it seems like there was one other question, but I should have written them down. Anyway, those are a few more add-ons to the bill. I think it's a good bill and it's well-meaning and oh, the other part. Yes, historically, the last bid is allowed by the leaseholder. That's what we historically do. There's discrepancy by some as to whether that should be done or not. Since we've done it historically, we're going to add that as a second reading amendment.
Representative Banks.
Thank you, Madam Chairman. I appreciate the explanation of the good representative across the bighorns from me, that a second reading amendment is coming. I intend to move this bill forward, knowing that we can solve some issues that we're having with our landowners currently, with some preference given to them to purchase these pieces that have been part of their operations for some decades. So I think we're accomplishing a lot here. We're helping out our sportsmen with access. We're helping out our ranchers with headaches and the concerns that I wanted to address. I think we can address them moving forward. So I look forward to moving this bill forward. Thank you.
Majority Whip Western, no? Question having been called, all those in favor of Chairman Eklund's motion that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 107 do pass, all those in favor say aye. Opposed? Senate File 107 has passed the Committee of the Whole. Majority Floor Leader Nyman.
Thank you, Madam Chairman. I move the Committee of the Whole stand in recess until 2 p.m.
You've heard the motion. All those in favor say aye. Opposed? Motion carries. Committee announcements? Seeing none, then, Chairman Newsom?
Thank you, Madam Chairman. Our joint conference committee for House Bill 118 will meet at noon in room 113. Thanks.
Chairman Olson.
Thank you, Madam Chairman. Your House Corporations, Elections, and Political Subdivisions will meet upon noon recess. Grab your lunch and come on down to consider, two bills, Senate File 153, Election Security, and Senate File 164, Public Improvement Contract Requirement Amendments.
Chairman Northrup.
Thank you, Madam Chairman. Your committee number 4, Education, will meet upon noon adjournment. We have 4 bills, Senate File 83, Senate File 174, 133, and 132. We got a list, so we're going to get going. Thank you.
Point of order.
What's your point?
Thank you, Madam Chair. According to Rule 5-2, I would like to call a Rules Committee for improper notice on Senate File 133.
So the Rules Committee can meet up here, please? Representative Provenza.
Thank you, Madam Chairwoman. Because the Rules Committee, and speaking with the best chairman, has agreed to hearing this on Thursday, giving proper notice, I will withdraw my point of order, I guess. So thank you.
Thank you. The House is now in recess until 2 p.m.
Madam Chair. Madam Chair.
Chairman Eklund, I'm sorry. Nicholas.
Thank you. Your House Appropriations will meet in 5 minutes to continue its work on Senate File 144. And then also, we have 3 re-referrals, 141, 151, and 120. And Senate File 142 will be done after that. And then on adjournment, we have Senate File 146.
So we are in recess till 2 p.m.